Hello and welcome to Exploring the Legal Landscape of Delta-8 THC and Similar Cannabis Products. My name is Manir Bond, and I'm an attorney here at the Public Health Law Center, and I'm joined by my colleague, Ms. Rachel Callanan, who is a lead senior staff attorney, and Dr. Gillian Schauer, who's the executive director of the Cannabis Regulators Association. Before we begin our presentation, I just wanted to share a few things about the Public Health Law Center. The Public Health Law Center is located on the lands of the Dakota people in St. Paul, Minnesota at Mitchell-Hamlin School of Law. We are a team of dedicated attorneys, policy analysts, and support staff who work nationwide on public health policies in the areas of commercial tobacco control, healthy eating, active living, and health equity. The picture that you're seeing is actually a picture of our commercial tobacco team. So the Public Health Law Center does what's called legal technical assistance, which consists of legal research, policy development, implementation and defense, publications, and trainings. We do not provide direct representation and we do not lobby. Please note that PHLC's cannabis-related work is funded through the Robert Wood Johnson Foundation. All of our work at the Public Health Law Center is centered in health equity. This means that we work diligently to ensure that everyone has access to systems that promote healthy lifestyles. We are committed to removing all institutional barriers and applying an equity lens to our work to produce the best results for the communities we serve. Additionally, PHLC also subscribes to the social determinants of health model. This means that we recognize that there are several factors that influence a person or community's overall health, including but not limited to things like quality healthcare, racism, housing disparities, and other environmental challenges. During today's webinar, we are hoping to cover the following items. 1, what is Delta-8 THC and how is it regulated or not? 2, what are the lessons to be learned in regulations of newest products such as Delta-8 THC and similar cannabis-derived products? 3, what do public health advocates need to understand about Delta-8 THC and how does it apply to commercial tobacco work? And 4, practical steps to take in your state or community to promote public health. Before I turn it over to our special guest, I'd like to first introduce Dr. Gillian Schauer. Dr. Schauer is the Executive Director of the Cannabis Regulators Association, CANNRA, a nonpartisan nonprofit organization that convenes government officials involved in cannabis regulation from more than 40 US states and territories. CANNRA shares best practices and lessons learned to protect public health and consumer safety, advance equity, and harmonize policy to create predictability in markets. Dr. Schauer has worked in public health and drug policy for nearly 2 decades and has a decade of experience working with federal and state agencies on cannabis policy, data monitoring, and research translation. Prior to her work on cannabis issues, Dr. Schauer worked on tobacco prevention control with the focus of tobacco cessation and treatment. She was the senior editor on the 2020 Surgeon General's report on smoking cessation. Lastly, she has more than 70 peer-reviewed research publications on cannabis, tobacco, and other substances. She has a PhD in behavioral science from Emory University, a Master of Public Health from the University of Washington, and a Bachelor's of Science from Northwestern University. Please join me in welcoming Dr. Schauer.
Thank you so much, Manir. Let me get my slides up for everybody. And just want to start by saying it's an honor to present on this webinar. And, over the past 2 decades, I've really valued the work of the Public Health Law Center. So it's been great to work with you all on cannabis as an issue as well. And I think your participation on this particular subject matter is really important. So I think Manir set up very nicely what we're going to be talking about today. He also gave a great background on CANNRA. In case you wondered if your state is a member of CANNRA or not, you can see our map. We also have Guam and the Virgin Islands not denoted on the map in our membership. And as Manir highlighted, our mission and goals are not to lobby or advocate for cannabis legalization, but rather to equip policymakers and regulators with unbiased information to help them share lessons learned, to promote certain policy approaches that protect and safeguard public health, consumer safety, promote equity, and to try to harmonize policy where possible. So hopefully you guys are excited about the idea of an organization like CANNRA. We're relatively new. But in my disclosures, it's very important that I state that this presentation is my own. It's not an official position of CANNRA or any of the state agencies that I work with. And as you probably saw in the last slide, CANNRA has government members. We don't have any industry or non-governmental members, and our funding is governmental as well. So I don't have any funding disclosures. I want to start today in giving some background about Delta-8 and other cannabinoids. I want to start by just talking about the plant. I know all of you are coming to the table probably with a different knowledge of the cannabis plant. So this is the cannabis plant, and it has more than 100 different cannabinoids or individual molecules that are part of it that act in the body. Our body does have a system called the endocannabinoid system that works with those different molecules. And probably the two most well-known cannabinoids are THC, which I'm going to talk much more about. And that is the molecule that tends to be responsible for the psychotropic effects or the high. And then CBD or cannabidiol, which is not psychotropic. It does not alone cause a high. So we're here because of a gray area in legalization that I'm going to talk much more about, that some of you may have started reading about a year or two ago. The media started to pick up on it around December, January 2020, 2021. I will mention that regulators were meeting to talk about Delta-8 and hemp-derived cannabinoids well before the media started picking it up. But it has been widely covered in the media, and it's a complicated science-based topic. So that's why I want to do a little bit of a deep dive to start with. So THC has several different isomers. An isomer is basically a molecule with the same molecular formula, but a different arrangement of the atoms. That's the most simplified, I think, explanation I can give. I'm not a chemist, but you can see here, these are some of the isomers of THC. Delta-9, which is what most of our policy in this country and in states has been based on, Delta-8 and Delta-10. And these isomers are different by the location of one double bond. You can see it's placed differently in the arrangement of the atoms, based on whether it's Delta-9, Delta-8, or Delta-10. So it's slightly chemically different because of that, which can change the way it acts in the body. Delta-9, again, is what our policies have been based on. It is impairing or psychotropic. Delta-8 and Delta-10 are as well. And there's a paper that the World Health Organization put out a number of years ago that estimates that Delta-8 is about 50 to 75% as potent as Delta-9. But it's not been widely studied, and its effects on the body are not as widely understood as, say, Delta-9 THC. So why haven't you heard about Delta-8 THC until recently? What happened to sort of bring it into the mass media such that the New York Times and Rolling Stone were putting out articles about it? Well, as I said, most states have defined THC as Delta-9 THC in their state statutes. Federally, this has tended to be the focus as well. These other isomers, Delta-8 and Delta-10, are present naturally in the plant, but in very small quantities. You would need a lot of cannabis to extract out enough Delta-8 from the plant directly to produce Delta-8 products. But then enter the Farm Bill. So in 2018, the Farm Bill greatly broadened the definition of hemp and effectively legalized hemp federally. And hemp was legalized, the kind of nomer that was given was rope, not dope. So hemp was initially, I think, viewed as something that could be a commodity crop that could be used to make textiles, rope, etc. And while the Farm Bill was being debated, there was quite a bit of discussion about extracting CBD from hemp for dietary supplement-like products. And I covered CBD is not something that is impairing alone, but CBD can be synthetically converted in a lab using acids, solvents, and heat into different cannabinoids, including Delta-8, Delta-9, Delta-10, or as I'll talk about later, a range of other different cannabinoids. Obviously, the process of doing this conversion requires some knowledge of chemistry. There are certain solvents that may be better to use than others. There are certain acids that may be better to use than others. But the regulatory process that was set out in the 2018 Farm Bill really focused on the farming aspect. It did not focus on the conversion to other products, the processing, the manufacturing, or the sale. So the Farm Bill left Delta-8 and these other THC isomers and other cannabinoids that have since been converted from CBD in this gray area of legality. And I'm going to show you the specific language that created that. So the definition of hemp in the Farm Bill was something from the plant. I'm going to simplify. You can read verbatim on the screen. Something from the plant cannabis, and any part of that plant, including seeds, derivatives, extracts, cannabinoids, isomers, acids, salts of isomers, whether growing or not. And then this is the kind of crux of it, with a Delta-9 THC concentration of not more than 0.3% on a dry weight basis. So the entire definition of hemp was really hinging on Delta-9 concentration in the plant, and had this broad definition where it's not just the plant, it's anything that comes from the plant. I'm also going to come back to that dry weight basis. That ends up also being very important to some of what we're seeing on the market. So this created a gray area of regulation whereby individuals started seeing a surplus of CBD products and realizing that those CBD products could be converted into other cannabinoids, some that exist in nature and some that do not. So the DEA sought to clarify more than a year later what they meant by this definition, and their clarification was that all synthetically derived tetrahydrocannabinols, or THCs, would remain Schedule I controlled substances. However, they failed to define synthetically derived. And the chemical process of converting CBD into these other things, which is called isomerization, there's a lot of debate, even in the science community, about whether that's synthetic or whether that's chemical or some other derivation. So the fact that DEA did not define synthetic did not help resolve the situation. It continued to leave it in a gray area. There have been a number of court cases that have happened since the Farm Bill passed that have somewhat tested whether or not Delta-8 products are legal or not. The most recent one that you may have seen covered in the news was the Ninth Circuit Appellate Court decision, which just came out last month. That case was actually a trademark case over Delta-8 vape products. And the defendant in the case appealed the initial ruling, saying Delta-8 hemp was not legal under the Farm Bill, and you couldn't bring a trademark case on something that was an illicit Schedule I product. So the Ninth Circuit Court had to make a decision on whether or not Delta-8 products were legal. And they decided, in their decision, they wrote that the text was plain and unambiguous in the Farm Bill to indicate that Delta-8 products are lawful. They also added, though, that regardless of the wisdom of legalizing Delta-8 products, the court would not substitute its own policy judgment for that of Congress. So Congress can course correct. The court is reading the text from the Farm Bill in a very literal way and not adding its own policy judgment on top of that. So this might have seemed like a big deal. The media covered it fairly widely, but this was not the first court case to take this very literal reading of the Farm Bill. And in terms of experts I've talked with, both experts who are in the industry, out of the industry, in public health, out of public health, legal, non-legal, I think there's a consensus that this doesn't really do a whole lot to change the reality that we see on the ground. There's still a bit of a gray area, and states will still be trying to address policy in a state-by-state way, which I'll cover in this presentation. So what are we seeing on the market in light of the policy language that we just covered? We're seeing Delta-8 products being advertised mainstream in outlets nationwide. It started in just a few states, but now the market for Delta-8 products online is quite large. The market in states, whether they have adult use or medical use programs or not, is quite large. I do think there's been some evidence, which CDC mentioned in their health advisory notice that I'll cover in a second. There's been some evidence that Delta-8 may be more prevalent in communities where you don't have adult use policies in place. Increasingly, we're seeing Delta-10 products as well, although they've not picked up like Delta-8 products. And then we're seeing a bunch of other cannabinoids that do not exist in nature. Hexahydrocannabinol, or HHC, and THCO acetate are two that are pretty dominant in the marketplace that are not found in nature. And I'll talk a bit more about some of the concerns there. They are both much more potent than Delta-9 THC. We're seeing a range of product types, vapes, oils, edibles, even smokable products that have been sprayed with Delta-8. We're seeing a range of ways that these products are being marketed. They're being marketed as a high without the mental health or mental side effects like paranoia. They're being marketed with medicinal claims. And as I said, they're widely available in all markets. So what are the potential health and safety risks? I've thought a lot about this. I've testified in a number of states about these. I think first and foremost, THC isomers and these other cannabinoids that I've covered are psychotropic and impairing. So all of the things that we would be concerned about with something that can be psychotropic or impairing, we would be concerned about here. I think some of my big concerns circle around consumer awareness issues. The way that we regulate hemp products in most states is very different than the way that we are regulating medical or adult use products. And so most states have a regulator for hemp, but that regulator is primarily focused on the growing. They are not focused on the processing of products or the sale of products. And as such, that means that we don't generally see across states really stringent regulations for packaging, for labeling, for warnings. The testing that hemp products are subjected to is predominantly to make sure that they meet that criteria of the federal farm bill definition in terms of Delta-9 THC. There's no required testing for the actual amount of Delta-8 THC, for other contaminants that could be in there. And I think many consumers may see these products in places where they see CBD or hemp products and think this is not something that's going to get me high. This is a hemp product. When in fact, there can be quite a lot of Delta-8 or Delta-9 or other cannabinoids in there that can get you high. So the consumer awareness issue is a big one. We first started to see Poison Center reports more than a year ago. There was one in West Virginia, there was one in Michigan detailing exactly this. Detailing cases where, you know, an adult did not know that they were taking a product. So in the case of West Virginia, they didn't know that they were taking a product that could get them high. It was mistaken for a product like CBD and resulted in adverse effects. And then in Michigan, they detailed a case where two children got into, this is the West Virginia case, the Michigan case where two children got into their father's gummies that had been purchased at a vape shop and had very severe side effects, resulting in intensive care unit monitoring and oxygen supplementation. It appears that both children were okay, but this is a byproduct of consumers not understanding these products can get you high. They need to be stored out of reach, locked away from children. You know, consumers may not understand that these products warrant that type of approach. So the Poison Center calls continued to come in, and the CDC last September put out Health Alert Network notice that I imagine many of you saw, documenting some 660 cases of calls to poison centers, many of which were in youth, I think 18% of which required hospitalization of some sort, or, you know, encounters with medical facilities. The FDA has also issued some notifications. So they issued an alert about Delta-8, a sort of health alert about Delta-8, coinciding with CDC's alert that came out in September. The FDA in the Farm Bill could have regulatory authority over these products if they wanted to. And generally, we've not seen them take a lot of that regulatory authority. So what we've seen them do is issue this health alert. We've seen them issue a handful of letters to a small number of companies selling Delta-8 products and marketing them with, you know, medical claims that were seen to be unfounded. And we've seen them announce that they're going to be collecting data around cannabis-derived products to better understand their place in the market. The regulators named in the Farm Bill were the USDA and the FDA. The USDA has generally focused their regulation, as we've seen in state departments of agriculture, on the farm and on the growing process. And there's a gap federally in any regulatory authority being taken after those products leave the farm, after those products are processed into something and sold as something. And so in the face of that gap, states have come up with their own policies, which I'll cover. So that's a summary of some of the consumer awareness issues and some of the lack of regulation to help address some of those issues at the federal level. Another concern with these types of hemp-derived products is youth access. These products are widely available online and in the hemp marketplace. So whereas the adult use and medical marketplace for cannabis has generally been extremely compliant in adult-only sales, there was just an article that some of you may have seen out of California showing in a study that their adult use cannabis outlets had 100% compliance with adult-only sales. It's a very different landscape for medical and adult use cannabis than we see for tobacco. Medical and adult use cannabis are sold in age restricted stores that are 21 and older. Most of them have required ID checks at the door, and most of them are only allowed to sell cannabis products. So very different than what we see for tobacco. Hemp, on the other hand, looks a lot more like what we see for tobacco. Hemp products are allowed to be sold in corner stores, in grocery stores, in gas stations, in pharmacies, in coffee shops. You are probably all seeing these types of products all over your communities because there aren't the same restrictions on them that there are on medical and adult use cannabis. So what this means is hemp products in general are much more widely available to youth. And that's concerning when we consider the range of impairing products that are coming out of hemp constituents. In addition, the online marketplace for these Delta-8 HHC, THCO products is concerning as well. So any of you right now can go on Google and find a site that is selling these products and probably not have to do much more than click a box saying that you're over 21. So the age restrictions for hemp look very different than for cannabis, making these products much more available to youth, which is concerning. Another concern is the processing and testing. The development of these products from CBD into Delta-8 or HHC or THCO is a chemical process, and that chemical process can have byproducts and contaminants that are not being tested for, that we are not looking for, and in some cases that we do not understand the safety effects of. So I'm going to cover a report that was actually put out by a cannabis industry group, the US Cannabis Council, simply because state and federal agencies have not had the capacity to do much testing on these products. And so this report is very useful in that regard. They tested 16 different Delta-8 products that they purchased off of the legal hemp marketplace. Testing was conducted by Proverde Labs, which is a cannabis lab testing company. What they found is that all of the products contain Delta-8, although they may have contained very different levels than were indicated on the label. Some contain Delta-9 THC, and the mean concentration of Delta-9 THC in the products was more than 10 times that USDA limit of 0.3%. Part of the reason some of them may have contained Delta-9 THC is in the chemical conversion process to get from CBD to Delta-8. It is possible to accidentally convert too far or not enough and end up with Delta-9 or Delta-8. Lead was detected in a number of the samples, as were other metals and residual solvents. And then I think of particular concern for public health. In each sample, there were at least 7 to 10 compounds that were of unknown identification. Byproducts from the conversion process that could not even be identified. And given that many of these products are being aerosolized, I think all of us know the potential concerns with having unidentified products that are in a vape cartridge that will be aerosolized. So that leads me to kind of the cautionary tale and why I have been fairly outspoken on this issue for the past couple years and have testified in states about it. I think all of us watched what happened with the vaping lung injury outbreak, which peaked in 2019, resulting in deaths and hospitalizations across most states. That outbreak was from largely unregulated cannabis products that were being obtained from illicit or informal sources. It was a result of unsafe byproducts and diluents that were in those vape cartridges, and vitamin E acetate was named as one cause. So we have a very similar situation, in my opinion, here, where we have largely unregulated products. There's not oversight of the additives that are being included in these products. There's not oversight of the byproducts and the chemical processing of them. There's not good labeling, and there's not the ability to conduct recall in the case of adverse effects. So that's one of the reasons I think this issue is particularly important for public health to be engaging in. Nobody wants to see another vaping lung injury outbreak. And I feel like it's only a matter of time before we have another situation like that, given the unregulated landscape we have now. Lastly, and probably an area that public health may not think a lot about, but is very important, this particular landscape for hemp really undermines the regulated medical and cannabis marketplace. And lots of your lawmakers, policymakers, government officials involved in regulation have put a lot of care and thought into trying to make those legal marketplaces as safe as possible for consumers, trying to prevent access to youth. And those markets, in my estimation, are going to really struggle if we continue to have a parallel market that has far lower barriers to entry. It's much easier for somebody to be in the hemp marketplace than it is for them to be in the adult use or cannabis marketplace, because there's not as big a focus on consumer safety. And so the cost to get a license, whether or not you need a license, the costs related to testing and packaging and labeling are very different. And as long as we have these parallel markets where one has lower barriers to entry, I think it does compromise the thinking and attempts at careful policy in the adult use and medical use cannabis market. So I've spent most of today talking about Delta-8, which I would say is a bit of yesterday and today. But as I mentioned, the landscape changes constantly, and this is a very dynamic area in terms of the compounds that we're seeing. So we are seeing lots of THCO acetate on the market now. We are seeing hexahydrocannabinol or HHC. Both of those molecules, as I mentioned before, are not found in nature. In addition to being chemically produced, they don't mimic anything found in nature. So humans that are buying products with those are the test case. We have no safety profile for those molecules. We don't know what they do in the body. There are other things that can be found in nature but are being made synthetically and maybe impairing as well: THCV, THCP, et cetera. And then there's another tangential issue that I also think is important that you may be seeing in your communities, and that's the amount of legal Delta-9 THC that you can find in hemp-derived products. And this stems back to the Farm Bill definition of Delta-9 THC as being a dry weight measurement. So what that means is plants that are grown in the field have to have less than 0.3% Delta-9 THC in the plant when it's dried. However, you can take those plants and you can extract out a lot of THC, even if they're at the 0.3 threshold. When you're extracting, you can get a lot of THC in a concentrated form for edibles, for beverages, et cetera. So for example, and this is an excerpt from some testimony that the Oregon Liquor and Cannabis Commission gave on their House Bill 3000 that related to hemp. It's possible to have a compliant product for the Farm Bill that is 0.3% Delta-9 THC. And when you extract that out, you can have a 20-gram pack, a fun size pack of gummies that has 60 milligrams of Delta-9 THC legally. Now, in Oregon, at the time of this testimony, their adult use cannabis marketplace had a limit of 50 milligrams of Delta-9 THC. So you could legally have more Delta-9 THC in a hemp product than you could in a regulated adult use cannabis product. So this is another really important issue, and all of the same caveats about these impairing products being available to youth, being available in more outlets, being more readily available holds here as well. So I think policy approaches, shifting to kind of what have states done to respond to this, policy approaches that states have pursued have considered allowing these products on both markets. So you could allow them on the adult use market and on the hemp market and try to bring, regulations up to have some parallel. You could outlaw these products on both markets and have a ban. You could regulate these products on the hemp side, but not on the adult use side, and try to bring regulations on the hemp side, up to a level that assures some consumer safety. Or you could outlaw these types of products on the hemp market, but allow them on the regulated cannabis or marijuana market and regulate them in the same way there. The considerations and challenges in debating this issue, this is highly technical. It's a subject that legislatures often struggle to understand because it involves chemistry. It is extremely technical, and legislators are not just focused on cannabis. They're rightfully focused on a range of important issues. So there can be a bit of an education gap. There's disagreement on how we should define impairing and where to draw the line there, and what compounds might be on the impairing side of the line and what might not be. There's disagreement about what to do about non-natural synthetics like THCO acetate and HHC, cannabinoids coming from hemp that are not found in nature. And there's disagreement about what to do about biosynthetic cannabis, which I haven't even covered in this presentation, but that's the ability to use yeast or algae to mass produce cannabinoids like THC. So all of these issues tend to enter onto discussion that legislatures have had about what to do about hemp-derived products. Hemp and cannabis regulators in states sometimes work closely together, and there's a huge advantage when they do. Sometimes they don't. There can be political issues between those agencies that can create challenges. And then having testified in many states on this issue, I can tell you that public health testimony is often missing from legislative discussions on this issue, and that's an important gap. So what have states actually done? I'm going to start with Minnesota, the Public Health Law Center's home state, because they just recently made news with a bill that passed regarding hemp. Minnesota, to give you the landscape, is a tightly regulated medical only state in terms of their cannabis policy, with just a handful of licensees. And they've traditionally had tight regulation on the types of medical products that are available as well. But a bill was signed in May of this year to legalize hemp-derived products. That bill at the outset seemed to have the right ethos in mind. They defined non-intoxicating as substances extracted from certified hemp plants that did not produce intoxicating effects when consumed by any route of administration. And as I understand it, the goal of the bill was really to figure out regulation for intoxicating hemp-derived products and what to do with non-intoxicating hemp-derived products. But then in the text of the bill that was signed, they define the allowable serving size for hemp products as 5 milligrams of THC per serving and 50 per package, which again, there are several states that have that threshold in their adult use policies. So this bill effectively set a threshold for the hemp industry that is the same as the adult use cannabis industry in a number of states. 50 milligrams of cannabis is quite a lot. 5 milligrams is a lot for individuals as well. If you were a naive cannabis user and were to go into a retail store, they would probably start you with a 2 milligram serving size. Certainly, 5 would be at the very high end of what they would want to start a naive consumer with. And then these products will be allowed for sale wherever hemp products are sold, but with a 21 plus age limit. So they'll be trying to age verify in ways that we have seen in the tobacco industry as well. This bill relates to beverages and edibles only, and they will be allowed to be sold starting July 1. Interestingly, the medical cannabis market in Minnesota also decided to start allowing edible products, but the medical cannabis licensees in Minnesota will not be allowed to start selling medical cannabis edibles until August 1. So the hemp industry will be able to sell what I would consider to be impairing edibles a month before the medical cannabis industry. So interesting. I think this is an example where the legislature, probably was really trying to address an issue that they saw as being a public health challenge, but they may not have understood that 5 milligrams per serving is actually quite a high dose to just have available anywhere hemp products are available. So to contrast Minnesota's bill, Oregon through House Bill 3000, they also sought to address these hemp products, especially those that were impairing. And what their bill basically did is bring all of those impairing products under the umbrella of their adult use or recreational use cannabis regulator. They defined an adult use cannabinoid. They defined an adult use cannabis item. They defined artificially derived cannabinoids. They immediately prohibited the sale of these adult use items to minors. And they allowed the cannabis regulator, the Oregon Liquor and Cannabis Board, to set potency and concentration limits for how much THC would be allowed to be sold in the hemp marketplace. with higher items being on the adult use marketplace. OLCC initially proposed a serving size of 0.5 milligrams of THC per serving. And then in the rulemaking process, after feedback from stakeholders, that moved to a 2 milligram serving size with 20 milligrams per package. Again, 20 milligrams of THC per package can absolutely get you high. And that's, what's going to be available on the hemp marketplace in Oregon. But in general, they have brought these impairing items over to OLCC to be tested, to be regulated in terms of packaging and labeling, to be tracked for potential recalls. They also had a portion of the bill to address public safety and illicit grows, which I'm not talking about as part of this presentation, but some states like Oregon have seen marijuana grows that hide in plain sight in places where hemp growing is prevalent. The last state I'll cover is Michigan, just yet another approach. So Michigan's House Bill 4517, which passed in 2021 about hemp, defined THC more broadly. It moved the state definition beyond Delta-8 and included any THC isomer and included whether THC was artificially or naturally derived. It again gave the Cannabis Regulatory Agency in the state authority to promulgate rules for standards for safe cultivation, processing, and distribution, for testing, for packaging and labeling, and it allowed them to assess a process for safe production, including setting a maximum THC level in products. Since that House bill passed, they have also had an executive reorganization order so that hemp is now going to be regulated in terms of all processing and distribution and sale under the state medical and adult use cannabis regulatory agency. So they're bringing all cannabis products under one roof. So in conclusion, and I know I've covered a lot, so happy to take questions. This is a dense topic. CBD is being chemically converted into a number of impairing cannabinoids, some that exist in nature and some that don't. Hemp-derived products have a range of public health and consumer safety concerns, including that they are widely available to youth. The safety profiles are unavailable or do not exist for a number of these new cannabinoids that are being derived from hemp and entering into the marketplace. Federal regulatory inaction has pushed this issue to the states, and we are generally seeing a state-by-state approach here with a bit of a patchwork of policy across states. And public health has an important role to play in education and policy, especially given the consumer safety and youth implications of what we're seeing in markets. So with that, I think, Rachel, we're going to go to you before we take questions. But again, happy to hear from anybody with questions. Thanks for your time.
Great. Thank you so much, Gillian. This was just amazing information to share with everyone. So thank you for sharing your expertise. I'm going to share my screen quickly, and I'm going to cover just kind of what do public health folks need to understand about these issues. And so I'm going to go through a few slides here. So, in general, public health folks are doing a lot of this work on the ground. We're out there in the communities. We are often doing assessments or store audits around commercial tobacco products. We may be involved with inspections for, tobacco 21 compliance checks and that sort of thing. So as a result of that, Public Health Law Center started seeing a lot of questions coming in about these products that local public health people were seeing out in the communities. And so this is a photo I'm showing here of a storefront in South St. Paul, Minnesota, just 2 storefronts down for where I take my dog for dog training. And you would, with, the prominence of Delta-8 and the marijuana leaves, you would think that Minnesota has a legal adult use state, and we are not. So I just wanted to share this image with you. But so I'm going to talk a little bit about where we're seeing these products pop up, and Gillian talked a little bit about some of this, but we're seeing, vape shops, tobacco product shops. This image in the middle here is the cannabis CBD shop in Mall of America, is selling these products. And I will say this photo from St. Paul, you'll see that they're kind of jumping the gun with the new legislation in Minnesota and are actually, touting themselves as a dispensary for Delta-8 THC and CBD. So, we're seeing a lot of these products out in the marketplace, but also significantly online and available very widely online. So what do the products look like? And Gillian had some great examples too. I wanted to share a few examples. Again, from Minnesota, some of our partners at Association for Non-Smokers Minnesota were doing a store audit, and they came across these products. And so the first is this, electronic delivery device, smoking device, that is Delta-8. And then the other products that they saw were these edible products that look exactly like very popular candy that, your 8-year-old kids are asking for all the time. So, and they're really indistinguishable from the actual candies. And then this photo above shows exactly where they were located in this convenience store. And you'll see, thankfully, they were being sold behind a plexiglass divider, but that's not always the case. So we're seeing the products in a lot of different forms, and some of the marketing angles are, of course, to make these attractive to youth. So the FDA has issued a warning about these products, and so I want to just emphasize that to you as you are approaching these products in your community. I feel like I hear a lot from folks like, well, if it's on the store shelf, it must be safe. It must be regulated. Somebody's doing some kind of safety testing to make sure that they are safe products. And that just simply is not the case with a lot of these Delta-8 and similar products. So, definitely, heed the warnings from the FDA on these products. So what can communities be doing specifically to address these products? A very first step is to determine if these products are being regulated in your state or your local community. And so a good place to start is to identify if you have any state agencies, state regulators that may have some authority to regulate these products. And then if they do, identify what their specific reporting process is or complaint process so that you can follow through if you are seeing any violations of the law. And then, as Gillian pointed out, public awareness is absolutely critical. Many people do not realize the potential harms of these products for children, for pets getting into the products, and even for adults who think that they are consuming one thing, but they are consuming something that is actually going to be impairing to them. So, that public awareness for all of you as public health advocates is a perfect role for you. So work with, if you do have state cannabis regulators, work with them. They often are the foremost experts in this area and understand the different types of products. So working with them to just even let them know what you're seeing out in the marketplace. Often state regulators are, they're not working directly in the community, so they need to be notified. So if you're seeing things in the community that are concerning to you, just the simple act of reporting and informing those state agencies is a really important role. And then identify, like I said, which agencies may have some regulatory authority over these products. And in your state, that might be the State Board of Pharmacy, with regulation over drugs or things that purport to be drugs. State Department of Agriculture often has regulation over food products and food safety. And then, of course, the state attorney general and law enforcement may also have a role to play in monitoring and identifying any potential violations for the manufacture and sales of these products in the marketplace. And then last but not least, talking about urging greater federal regulation over these products. There is existing authority under the Food, Drug, and Cosmetic Act. And Gillian talked about that a little bit. The FDA has exercised that authority, but to a very limited way. And so, that is one of the reasons that these products are so widely available out on the marketplace right now. And that steps and states and local communities are they're forced to take some steps to try to protect public health. So again, what else could you be doing as a public health advocate, and what you can be doing in your local communities? Well, I mentioned a little bit about drug regulations, food regulations, identifying where there might be some intersection of existing regulations in this area. So often that is going to come in that intersection with drug regulations, or if the Delta-8 or similar products are being sold as food products in those food regulations. So look for those kinds of intersections and, attempt to make sure that at a minimum, they're at least anyone manufacturing and selling these products are at least abiding by those requirements. And then, Public Health Law Center, we spend a lot of our time working on commercial tobacco regulation. And so, of course, we are looking at those intersections. So two key intersections there are looking at clean indoor air or smoke-free policies. And that could be at the state level, local level, or even individual policies. So for smoke-free housing, smoke-free workplace campuses, school campuses, that sort of thing. So the idea there is to really make sure that the definition of smoking is broad enough to cover smoking these types of products, whether that be smoking a combustible form of the product or using it as an electronic smoking device or vaping the product. Make sure that people are protected from secondhand exposure of these types of products. And then a second arena is that point of sale arena with commercial tobacco products. If the product is being sold as a vaping product and electronic smoking device, some of your regulations for point of sale, so like minimum legal sales age and that sort of thing, may apply to these products. Again, it will depend on your definition of these products and whether it's broad enough to cover these types of substances. And in some states and local jurisdictions, it is limited to those nicotine containing products. So you will want to look at that and be clear about what your definition for these types of products might include. And so I wanted to just reiterate a Minnesota example. In Minnesota, and this is before the legislation goes into effect. So this is going to change in Minnesota, but currently the Minnesota Department of Agriculture had made a statement that food products containing Delta-8 were not legal for sale in Minnesota. And then similarly, the Minnesota Board of Pharmacy had also made statements that non-food Delta-8 products were not legal for sale because they were impairing, they were intoxicating. And so that was part of where they could step in and regulate the products. So, and, Gillian noted the legislation in Minnesota. So this landscape under that, those two areas is going to change in Minnesota. So I want to flag that for you. But then the Minnesota Clean Indoor Air Act does apply to any types of substances that may be smoked. And that would cover anywhere that act prohibits smoking. These products would be prohibited. So I saw you join the video. Gillian, did you want to chime in?
No, I was just joining for Q&A when we get there.
Okay. So the last thing I just wanted to mention is these are our definitions in the Minnesota Clean Indoor Air Act for smoking. And so you'll see that it clearly covers marijuana or other plant, whether natural or synthetic. It also includes activated electronic delivery device. So we have a nice, really great comprehensive definition in Minnesota. Again, not every state has that. So you'll just want to be aware of that. And then we also have a good definition of electronic delivery device that covers a whole range of natural and synthetic products and not just nicotine containing products. So again, our state laws for youth access and that sort of thing would apply to any Delta-8 products that are being sold in this way. I want to emphasize, however, that looking for ways of regulating these Delta-8 and similar products through existing laws around commercial tobacco is not a comprehensive way of addressing these products. And so if, it's great if some of these things are covered in your law, but it's not a substitute for comprehensive regulation of these products, which Gillian gave some really good examples of approaches that states could take. So just want to share some resources quickly. We have a webpage on our website devoted to commercial tobacco and marijuana resources. And we have a fact sheet coming very soon, specifically around Delta-8 THC products. And with that, I will stop sharing so we can answer some questions.
Okay, thank you, Rachel and Gillian. Just a few questions. I've combined a few of them, and I'll go to you first, Gillian. So the first set of questions is really about the consumption of Delta-8 products. Someone wanted to know specifically, do Delta-8 products come up on a drug test? And then the second question is, how much Delta-8 THC is actually a dangerous amount?
Yeah, so there's not good science on this, but I have been told by several lab folks that yes, Delta-8 would result in a positive drug test, as would the Delta-9. And I think somebody asked about this, is there Delta-9 in CBD products that people may be consuming? They're hearing anecdotal stories of people who are buying CBD and feeling high. Yes, I mean, that's not required on the label that people put how much THC is in the end product. All they have to put is that the product was compliant with the Farm Bill, which means the plant, when it was grown, had 0.3% or less THC dry weight. So yes, you can have THC in CBD products that may not be labeled. Those products can result in a positive drug test. We don't have good data to know how much Delta-8 THC is the right dose or a dangerous dose. Again, it's a cannabinoid that has not been nearly as widely studied, but I do think it's instructive to know that most recreational or adult use markets have set a threshold of a 5 milligram or 10 milligram serving size with a maximum of 50 milligrams or 100 milligrams per package. And if you go to these retail stores, again, if you're a naive consumer, they will start you much lower. So somebody I think noted, they've seen products with 800 or 900 milligrams of Delta-8 THC. That is a huge amount of Delta-8 THC and would be concerning, not just for accidental ingestion by youth, but for the consumer themselves as well. Yeah, so I think those are some quick answers there. I also saw a question about, how are marijuana companies able to make products that look almost identical to candy and not get in trouble for their marketing? And Rachel had some pictures of these as well. I just want to clarify that medical and adult use markets have very strict regulations around packaging, and you are not likely to find those mimicking products in medical or adult use markets. There are certainly still products that appeal to children. That's a whole separate conversation that we could have, but you're not going to find the Stony Patch Kids or the ripoff of the Reese's or whatever it may be. But there's not the same packaging and labeling regulatory oversight for hemp products. And so a lot of those Me Too mimicking products are on the hemp marketplace and are appearing as Delta-8 HHC or THCO products. I think lawsuits may catch up to those entities, but there's not a regulator who's sending enforcement and compliance officers into the field to make sure, or who's pre-approving packaging to make sure that there aren't issues. So again, very big differences between the hemp side of the house and adult use or medical. Rachel, I don't know if you want to jump in on the lookalike products. Any thoughts you have from the legal perspective there?
No, I mean, I think that there, definitely those purveyors of the legal products are taking notice of those and, lodging some challenges to some of those manufacturers. But again, it's very difficult sometimes because they're in these stores and may not be found and may be out there on the market for some period of time.
Thank you both. Rachel, I'm going to hop to you. There is a question just about enforcement. So the question is, how do states that are creating policy around hemp products enforce those policies? So you have any thoughts, just, how states should think about enforcement, specifically from an equity perspective?
Yeah, I mean, I think the goal should be to keep the products out of the hands of kids primarily. And so, some of the regulations that we see for commercial tobacco could be informative of that, doing inspections to see if those products are being sold in the stores. And if they are, confiscating those and making sure that they're not available if they are not legal for sale in that state. I think a lot of times it relies on a complaint process, that there aren't proactive inspections that are happening. Unfortunately, there just aren't the resources. So, and that's where public health advocates could play a role. If they happen to see some of these products, to let their regulators know that these products are out there. And so I think, again, focusing on the sales and manufacture of these products and the enforcement of the protections that are meant for public health and safety on those fronts should be the foremost strategy for enforcement.
And I would just add, for the handful of states that have brought these products under the umbrella of their medical or adult use cannabis regulator, they do have very detailed processes in place for compliance and enforcement that are proactive. So that's one of the benefits of moving these impairing products under that regulatory umbrella. They already have systems in place, and those products should only be available on certain markets once that happens in a state. I think the challenge is if you're in a state where maybe you don't have a medical or adult use cannabis regulator, or if you're in a state where hemp is still a very separate regulatory process and these products have not been brought under that umbrella, that's a more challenging situation.
Thank you. I recognize that we're at time. Do our panelists have a few moments for one last question? Okay, I'm getting the okay. So last question. What do you think is the biggest regulatory threat to intoxicating hemp-derived cannabinoids? In other words, if these products are going to be seen to see a nationwide crackdown, do you think it would come from the feds via the FDA, DEA, or possibly the 2023 Farm Bill, or from a piecemeal state ban on restrictions?
Yeah, so I think the reason we're seeing the state-by-state approach is that we've not seen federal action. And I don't think anybody's holding their breath for federal action. We love our partners at federal agencies, but we all know it took the FDA 10 years to regulate menthol in tobacco, and there was a lot of science there. This is a much more challenging area where there's not a lot of science. And so I would be surprised if we see federal agencies act. I do think we will see attempts in the next Farm Bill, which is up for debate and passage this fall. And I think we will see entities trying to close these loopholes, and the entities that may be most influential there may be from industry. So I think that's another place where public health evidence from your communities and vocalization of kind of the pillars that matter most will be important. But I don't think we're going to stop seeing states try to address this issue. Even a Farm Bill approach to addressing this is unlikely to be sweeping. I think it might be kind of an incremental change. And so we are still seeing this state by state approach that I think presents challenges when every state is doing it a little bit differently. And that's where webinars like this and hearing from folks in communities about what's working is going to be really important, so that we can arrive at best practice approaches and try to bring states along in adopting those to have more consistency across states in how we handle these products.
Anything to add, Rachel?
No, that was great. Thanks, Gillian.
Yes. Okay. Well, with that, I want to thank both Rachel and Gillian for your time today in exploring the legal landscape of Delta-8 products. Stay tuned to more updates from the Public Health Law Center, specifically a publication regarding Delta-8. We thank you again for joining us and hope that everyone has a safe and restful weekend. Bye.
Thanks so much.